So in November 2007 in Wisconsin, a guy slips RU-486 to his girlfriend and causes her to miscarry. And in Wisconsin, they arrest him and charge him with murder under the fetal homicide law, which was passed in 1998. And that law says anyone who attacks a pregnant woman and injures or kills her fetus can face life in prison. So here he slips her the morning after drug, right? RU-486. The baby is what, 2 days old? And he is actually tried under the fetal homicide law. He has since skipped the country, and we're going to see where this would go. But that's a phenomenal attempt to bring the fetal homicide law down to 1 or 2 days in conception. I'm going to jump to Chicago, Illinois. And in Chicago, Illinois, we have a case where a husband and wife produce some embryos in vitro. And they are storing these embryos cryogenically at a clinic, right, under contract. And they're going to store these embryos and try to implant for pregnancy over a course of time. Well, something goes wrong at the clinic. The cryogenic storage facility breaks down, shuts down, and the embryos are lost. Now, typically under the law, you would sue under breach of contract or negligence theories, right? They paid money to have these embryos stored, and the clinic failed to perform under the contract. Well, they also sued under what's known as the Wrongful Death Act of 1980 there in Illinois. And the notion there is that if you willingly harm a fetus, that you can be subject to wrongful death action for damages, right? So they sue under this, and in his ruling, Judge Lawrence says he's going to allow the lawsuit to go forward because it says children are, if they're killed in an accident or assault, regardless of their state of gestation or development, he's going to allow this to go forward because this is the language of the statute. He goes further. A claim lies for wrongful destruction of the embryo, whether or not it's implanted in its mother's womb. Philosophers and theologians may debate, but there's no doubt in the mind of the Illinois legislature when life begins. It begins at conception. Now, do you see what I just gave you? I just gave you a Wisconsin criminal statute. I gave you an Illinois civil statute, both of which are saying life begins right away. In one case, RU-486, right, at 2 days after conception. In the other case, cryogenically preserved embryos. In both of these cases, they're saying that's life. Now, when I compare this across the board with constitutional law, right, Roe v. Wade and the lineage of cases there, Casey v. Planned Parenthood, etc., it seems that the woman's right inherent in her own body, her right to privacy, somehow trumps the life that's growing inside of her, the protection of that growing life. And yet we can see the discord, we can see the disconnect when we have constitutional law, criminal law, civil law, all differing on when we're going to protect life. So I just want to toss this out as this is not an easy answer. You don't have to be a religionist to somehow have this higher than holier than thou moral position. This is tough for everybody. This is tough at the state level, the federal level, the constitutional law, civil law, and criminal law level as to when does life start and when are we going to protect it.